schedule for this noon and afternoon, and therefore, without much further delay, I pass you the microphone.
Okay, thank you very much. I guess that you may become suspicious of me because I'm taking the floor all the time on so many issues that I risk becoming expert on everything, which means probably expert on anything. But indeed, there is at least a clear connection between the topic of today and the human rights and the Council of Europe, because as everybody knows, I guess, the Council of Europe, in a sense, is identified as a political organization with the defense and fostering of human rights among its member states. And the first and fundamental achievement of the Council of Europe has been, and currently still is, of course, the European Convention for the Protection of Fundamental Freedoms and Human Rights, plus all its protocols. And as I said yesterday, this is a fundamental convention in as much as it proclaims some rights, gives access to those rights by all those who fall under the jurisdiction of a party, and establishes a mechanism whereby compliance with the convention, in other terms, respect and protection of those rights, is secured by an independent tribunal, the European Court of Human Rights. So, in a sense, it is a perfect system, which has a number of shortcomings, but nonetheless exists, and a huge merit of existing. As such, it has not been copied, although very quickly after the adoption of the Human Rights Convention, the issue was raised. We need a second convention to protect not only fundamental civil and political rights, those of the convention, we need a second instrument to protect social and economic rights, and potentially also social and economic and cultural rights. And this debate was held in the Council of Europe in the 50s at the initiative of the Parliamentary Assembly of the Council of Europe, and led to the adoption in 1965 of the European Social Charter, which is the second fundamental convention on those issues, which nonetheless does not contain a specific provision on cultural or educational rights, only social and economic rights. Also, the mechanism for proclaiming, ensuring implementation, and checking compliance is totally different. There is no individual right to access, let's say, a tribunal. There is no international tribunal. The court is not entitled to ensure implementation of the charter. The system is different because of the very nature of a social and economic rights, and lawyers can argue endlessly about this and about the distinction with civil and political rights. So the third area that remains uncharted is, so to speak, that of cultural rights in general, or access to culture, or the protection of fundamental rights from the point of view of culture, or what is culture and who has rights to culture. This is very large and difficult areas, one could say, which in the Council of Europe and in the course of the years has been addressed through the angle of, say, specific themes or specific areas, such as the rights of national minorities or individuals belonging to national minorities, the rights of those who speak a regional or minority language, so they have access to publications of freedom of expression in those languages, the rights of those who belong to, so to speak, a cultural community, which is the commitment of local communities to the ownership and enhancement of their traditions. This is, one would say, in short terms, in kernel, the Faro Convention, which promotes, in a sense, the access to and belonging to cultural communities, which are built around the traditions, languages, monuments, sites, etc. So the notion of, say, cultural rights is, in a sense, addressed by the Council of Europe, say, indirectly. There is no clear proclamation. What we have is in the jurisprudence, the case law of the court, when checking compliance by member states with the convention, and some rights of the convention, checking to what an extent limitations to the freedom of expression of artists, for instance, limitation to the freedom of expression of writers, novelists, journalists, limitations to the freedom of association of creators, etc., are justified in terms, according to the convention, in spite of the fact that those who use those rights, implement those rights, so to speak, are artists. In other terms, to what an extent limits can be imposed upon the freedom of expression of artists, the freedom of expression of novelists, etc., in the name of the protection of public order according to the criteria of the Human Rights Convention. In this way, if one looks at the jurisprudence of the court, one finds that cultural creativity, access to culture is not unlimited, because some limits may exist and member states are entitled to put some limits wherever the morals, public order, the freedom of others is in question. However, I'm not a specialist, but it would still be difficult from a number of individual cases to draw clear guidelines or clear-cut solution to problems. Each case, in a sense, is different. Each situation in which a writer, a novelist, a creator, a painter, a movie maker, etc., finds himself or herself and is confronted with a restriction or prohibition, each case, in a sense, is to be judged per se. So, in a sense, what is prevailing, of course, is freedom of creation, is freedom of expression, is freedom of association, but some limits may exist. Is it sufficient ground to proclaim a universal right to culture or to cultural creativity or access to culture? Probably yes, although the political step has not been taken so far. So we are not yet at the stage of drafting the 17th or the 18th protocol to the Convention of Human Rights on cultural rights, on universal right, access to culture. Not yet, but certainly we are in the process of looking more and more frequently, more and more often to culture as a contribute to say human right, as a human right, access to an expression of oneself's creativity and initiative as a fundamental right. It is not enough to have, in a sense, the freedom to express, to speak, and to group with others. It is also fundamental to create, to be part of a cultural community, to be part of a national identity or individual identity or minority identity, to feel entitled to belong to a group and to express that in the forms which are the most appropriate. So there is certainly a gap to be bridged between culture, cultural creation, cultural identity, and expression of this as a fundamental right, a universal right, or fundamental right for the individual, but universal in the sense that all individuals should be entitled to that. In the Council of Europe, we are looking at that, certainly, not yet in the form of prescription, but certainly in the form of policy, in the form of promoting creation, promoting freedom of expression, and protecting it. There are good examples, some recent examples that I will only quote for ease of reference. Of course, some sad events which occurred in Paris at the beginning of this year, with the atrocious killing of journalists and satirists of the Charlie Hebdo newspaper, of course, sparked a wave of reactions with most of us, so to speak, certainly moved by what happened and proclaiming freedom of expression within, I would say, very, very wide boundaries, so to speak. And then again, it's the issue of where would one put those boundaries. But certainly freedom of expression, first and foremost, must be protected, must be proclaimed and reasserted every time. Second wave of work that we launched in the Council of Europe was about the new concept, so to speak, not so new actually, about the internet and internet of persons, the internet of, not the internet of things. Catherine is the author of the terminology. But the work was on promoting access to and making a free use of all the opportunities that IT, internet in general, IT, offer for creating, sharing, storing, modifying, changing artists' creativity, creation. So again, it is an issue of using the freedom which these tools provides to everyone, not only to access, which is a great thing, but to access, change, share, improve, and that makes, in a sense, a big challenge to cultural institutions, to citizens in general, and to lawmakers. That's why we have tried to sum up all these trends with some guidelines in an internet recommendation that is under consideration now by our Committee of Ministers. And when quoting the Charlie Hebdo example, I would then say that the reaction by our Committee of Ministers was a series of statements adopted between January and May at the meeting of the plenary, Committee of Ministers plenary in Brussels, restating the belief of member states of the Council of Europe in freedom of expression and respect, of course, for human lives. So these are perhaps just some steps. The next step could be indeed that within this reflection on the compendium and political policies and identifying trends and issues, of course, there is room for, let's say, additional work on this issue and to provide information on how member states deal with this human rights and culture issue in their domestic policies, and also see to what an extent the debate that is taking place among us can contribute to enriching our reflection in the Council of Europe as culture as a fundamental human right. So I thank you, you all, for taking part in this debate. I thank the city of Wroclaw for hosting so efficiently and so brilliantly so far this important meeting. And I wish we have now a very interesting debate, the results of which I will be no doubt impassioned to bring back home. Thank you.
Thank you, Alfonso. That's very promising. Maybe we are getting back some light. I don't know.